final case to come before the court this morning is Johnson versus CBRE, and there should be an appellant and 2 appellees here. As I said, this is Johnson, and each side will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes, and the appellees, I understand, are going to divide their time. All right, the appellant ready to proceed?
Yes, Your Honor.
Just let me know what you want to say.
May it please the court, my name is David Jansky and I represent appellate Deanna Johnson. I would like to reserve 5 minutes of my time for rebuttal. Thank you. This case involves 2 commercial entities, CBRE and Davy Tree, who have contracts through the Cleveland Clinic Foundation, in which my client Deanna Johnson is an employee of. The evidence shows that was presented to trial court that both Davy Tree and CBRE breached their contractual duties. We believe that the trial court impermissibly ruled that Davy Tree first does not owe a duty to Deanna Johnson, as they found that she was not an intended third-party beneficiary, but then even further went on to state that even if she was, that they did not breach their duty under the contract. And it's important to look at the contract of Davy Tree and what their requirement was here. Davy Tree being a commercial snow and ice removal company here, had the responsibility starting back in 2013. Our incident happened back in January of 2019. That snow removal was required at a 0 tolerance with a maximum of 30 to 60 minute response time for all the locations. Heavy snowfall and icy conditions, and that's the key here is with icy conditions, will require additional and continuous service by the vendor. All driveways, parking lots are kept clear of snow at all times. The melted snow tends to waterfall down slope patient lots, causing icy conditions which may require additional salting. When my client in 2019 left her shift, she was an RN, about 7:45, walked out into this employee parking lot to where there was an icy condition in that parking lot, which was caused by an elevated helipad that was built at the Cleveland Clinic location in Twinsburg a few years earlier. Both CBRE and Davy Tree were aware as early as 2017 of the condition that this elevated helipad was causing to this employee lot, in which it was causing water to cascade and waterfall, whether or not there was precipitation or not, whether or not there was snow or not, to then flow into the employee parking lot. And there was an email all the way back in 2017 from Davy Tree to originally the Cleveland Clinic, which was forwarded to CBRE, CBRE being the property management company here, stating that this condition continues regardless of whether or not there was precipitation. Furthermore, Davy Tree acknowledged that per the contract here, it was their responsibility both to monitor that condition and to then rectify it, basically meaning here to salt. As Deanna Johnson stated, prior to her event in the fall, Davy Tree did salt, and they would be out there continuously. However, there are no records to show that on January 3rd, when the meteorologist reports show that the weather conditions that day were a high of 33, a low of 29, and that there was water here in the employee parking lot, that they were ever present to perform their contractual duties here.
There was no on that date, January 3rd, rain or snow on that day, was there?
The meteorologist reports show that it was trace. 0.1 is what they said. And even for the days prior to that, the meteorologist reports show 0 with regards to snow or ice precipitation.
Is there any evidence in the record that Davy Tree or CBRE was told that there was a icy condition on the parking lot that day?
There's nothing in the record in which that specific day that they were told, but Davy Tree has acknowledged on previous occasions that they understand that that is their responsibility, that when there are potential icy conditions here, meaning the weather would drop to freezing or at or below freezing, that they are to monitor that condition. That was the understanding also of what CBRE has said and what the Cleveland Clinic has said, the responsibilities there of Davy Tree. And there are no records to show that Davy Tree was ever there on January 3rd prior to Deanna Johnson's fall on it.
What exactly, I'm trying to remember, when exactly did the water flow from the helipad to the parking lot? Was that after rain, after snow melted?
The testimony, Your Honor, there was, it would occur all times regardless of what the weather conditions were like. That is actually what led to CBRE, being the property management company, to determine that it was the second helipad that was causing the water condition to come into the employee parking lot. It was originally thought that there may be a leak in a fire hydrant, but that was checked out, and that was not the cause. Through the email chain there, it said, and then the first email was in March of 2017, which basically stated there that the condition occurs daytime or nighttime, regardless of the conditions. And then they came to a conclusion that that helipad acted like a sponge, retaining all this water, and then it would just flow out whenever. And my client has testified that you would see water there sometimes, 2 or 3 times a week, regardless of what the weather conditions were like prior to that.
So you're saying the contract then provided Davy Tree, if the weather dipped below 32 degrees, was liable to come out, was responsible for coming out and salting that area?
It talks about icy conditions, is what the responsibility says in the contract there. And therefore, knowing that...
What specifically does the contract say?
Contract sits there and says, and this is what I'll read here, that all driveways and parking lots are kept clear of snow and ice at all times. Melted snow tends to waterfall down the slope, patient lots causing icy conditions, which may require additional attention and salting. There's also a provision that says snow removal is required at a 0 tolerance with a maximum 30 to 60-minute response time for all locations. Heavy snowfalls and icy conditions will require additional and continuous service by a vendor. So therefore, it's not just when there is a snowfall to come out, it's also when there's icy conditions. And it's been through the testimony there that CBRE, Cleveland Clinic, and Davy Tree understood that that is, regardless of whether or not there was a snowfall event or not, for them to go out there and monitor that condition.
Well, the trial court hung its hat on the law that runoff water, it's well established that ice which accumulates as a result of water runoff without more is a natural accumulation of ice. So what do you say to that?
The trial court made the determination there that they determined that this was a natural accumulation as opposed to an unnatural accumulation. And they went on to sit there and say that they were not persuaded by the arguments there that we presented to the court, given with this man-made helipad. Prior to the second helipad being constructed, which was done in 2016, there was never any complaints about there being water flowing into the employee parking lot. The complaints stemmed after that second helipad, which was a man-made created object there, then that created now this water flow to happen. And it happens, like we said before, whether or not there was precipitation, whether or not there was rain, whether or not there was snowfall. And therefore, believe that it's our position there that it wasn't a natural occurrence here, that this is an unnatural accumulation and that happens.
Hasn't this court already made a ruling on that issue?
There are rulings there about, the natural cascading waterfalls as well too. And a lot of those decisions there have been talking about melted snow as well, which the contract even here says it's a contractual duty here that Davy Tree has to do it. Whether or not it is natural or unnatural, that contractual duty still stays on that. As it goes to CBRE,
Before you leave, Dave, I know you run out of time, but did the court find that they were not intended beneficiaries of the contract based upon the language of the contract that said there were no third-party beneficiaries?
that is correct.
What was your comment on that?
Well, and as our brief states there, that the testimony before that is that everyone understood it was the intent of the parties that the employees, in this area specifically, is the employee parking lot that they have to monitor and to remove snow and ice from. And that the Cleveland Clinic, as a corporation, only operates basically through its employees, and that's the argument that we make there. And that therefore, while Deanna Johnson is not a specifically named individual in that contract, the Cleveland Clinic is, and the Cleveland Clinic is its employees and agents and directors there. Therefore, this is what the contract was put in place there, was for her benefit. And that is actually what Cleveland Clinic testimony was, CBRE, and through Davy Tree, that it was for her benefit.
But of course, the contract says no third-party beneficiaries.
There is a provision there which does sit there and say no other intended third-party beneficiaries. That is in there, and that is what the trial court held. And that's where it said it wasn't persuaded by our argument that we
But is she
placed
a
before.
third party if she's an agent?
She's an employee
She's
there
an employee, so she's technically an agent of the.
of the Cleveland Clinic. She is,
Who else? I see what you're saying.
all the employees there of the Cleveland Clinic are. Now, a food service delivery person or something like that is not an agent, not an employee
Right, you don't
there.
perform Cleveland.
Correct, and, therefore, no other intended third-party beneficiary would be those other individuals there, not specific, not these employees there.
Or like guests that come to Cleveland Clinic.
Correct, yes, the patients are not, the Cleveland Clinic. They service patients, and it actually even said when they determined that Deanna Johnson was a business invitee, it talked about the mutual benefit that there was there with Cleveland Clinic and her services that she provides on behalf of Cleveland Clinic there. I do want to talk about CBRE's contract as well too, because
And counsel, I will warn you, you're at 4 minutes and 38 seconds. You can continue. I just wanted you to know you're in your vote.
I do appreciate that, Your Honor. CBRE is the property management company here for Cleveland Clinic, and they've held that position there since early of 2013 there. Now, part of CBRE's responsibility here is, one, to monitor third-party vendors, such as Davy Tree, to ensure that they are meeting the requirements of the contract there. I believe that the evidence shows that that was not done here by CBRE, as they were not out there salting or monitoring this condition on January 3rd. And there's no
We don't know
doubt.
when the ice occurred, do we?
We don't know when it occurred. We know that my client started her shift at 7 a.m. that day, and there was no ice that day. As we said with the meteorology reports there, we know that the high that day was only 33, the low was 29. There was testimony that when CBRE representatives left the Cleveland Clinic around 4:30, they testified they did not see any ice there. However, there's another 3-window gap there in which that is the time frame that we're now talking about here of when the ice potentially occurred during that time frame. But CBRE also has a duty that it comes to when there are known hazardous conditions, they have to investigate them, report them, and then rectify those so as to prevent future occurrences here. In 2017, CBRE was aware that this second helipad was causing this water cascading down and potentially causing this hazardous condition. While they recognized what the source and what the problem was here, they didn't do anything to rectify it at that time, which the contract requires them to do. Had they done that, and they had 22 months prior to my client's injury here, then this wouldn't have happened. Now, the trial court kind of said it was because of March of 2017 that they weren't aware of any other incidences. However, there's a follow-up email in July of 2017 that still talked about the water leaking. And so therefore, it was still a continuous problem there that was going on, in which CBRE did nothing to attempt to rectify it. And plaintiff's expert here said that that was both a breach of their contract and of the industry standard that they were required to do, was to put in something to prevent this from continuing to happen.
Are they the landowner, CBRE?
CBRE is not the landowner.
What
Landowner.
right would they have done to make changes to the land to correct this, or what particularly you suggested they could have done as a non-landowner to fix it?
They were to basically give suggestions to Cleveland Clinic, which there's no evidence to show that they gave any suggestions to Cleveland Clinic in which to rectify this condition that was going on here. But Cleveland Clinic, through their testimony, through their agents there, said that essentially it was CBRE's responsibility to handle these situations there for it. And like I said, they identified what the problem was, they investigated it, but the next part of the contract, which requires them to rectify or to implement a process of improvements, they didn't do that aspect of it. Had they done that, then it is likely that this incident would not have occurred. And it appears that it was as simple as putting a drain at the second helipad there to collect this water that was flowing off from it.
And you are at 1 minute, 11 seconds.
Thank you. I just want to then go on and briefly then talk about how we put together evidence here both through the testimony and through experts here that it was both CBRE who has breached their contractual duties as it relates to Deanna Johnson and the commercial entity here, Davy Tree, which breached theirs. Now, the trial court never addressed at all plaintiff's expert reports or expert testimony through that in rendering their decision on it. So I would ask that the court keep that in consideration. I appreciate your time in this matter.
Thank you. You may proceed.
Thank you. May it please the court, my name is Joe Fiorello and I represent CBRE Incorporated. CBRE views this case as a pretty clear-cut slip and fall on an open and obvious natural accumulation of ice, which is exactly what the trial court ruled in granting summary judgment for both CBRE and Davy Tree. Before I get to the natural accumulation of snow and ice, and that this is a clear-cut, open and obvious case, I want to address the contractual issues with CBRE. As appellant's counsel stated, CBRE had a contract with the Cleveland Clinic. CBRE breached no contract with the clinic. CBRE's duties under the contract as it relates to hazardous conditions that were reported to CBRE or potentially hazardous conditions was to identify, rectify, and or report. There was no stipulation in the contract that they had to rectify. Cleveland Clinic's representatives have testified that CBRE met those duties. As was noted, CBRE was only notified of one email about ice forming in this parking lot in March of 2017. CBRE immediately investigated, immediately determined that it was not a leaky faucet or hydrant, but rather snow melt, rainwater, or groundwater was coming off the elevated helipad trickling into the parking lot. CBRE immediately reported that to the Cleveland Clinic. The Cleveland Clinic's game plan upon getting CBRE's investigation, getting CBRE's determination that the hydrant was not an issue, but rather was the elevated helipad causing rainwater to trickle into the parking lot. CBRE's plan was to instruct Davy Tree to closely monitor this situation and heavily solve the situation. It is undisputed by all parties that over the next 22 months, there was not a single complaint about ice in that parking lot. Cleveland Clinic employees testified that they expected nothing more than CBRE after they reported to the issue after investigating in March of 2017, because all parties were satisfied that Davy Tree was on it, was adequately salting it, and nobody had perceived an issue in the next 22 months. So if Davy Tree plaintiff appellant has readily admitted multiple times, she would see wet pavement in the parking lot, and she walked through it every time without care, without any concern, because it was always heavily salted. That takes us to the other contractual point. CBRE cannot possibly be deemed to fail to manage Davy Tree when even plaintiff appellant admits Davy Tree was doing a good job. That was always heavily salted to the point where she never worried about walking through the wet pavement, even when the rest of the parking lot was dry, as she readily admitted. She would see one section of wet pavement. It was always so heavily salted, she walked right through it. Everybody agrees it was always salted. There was not a single ice complaint from March 17th till January of 2019, the night plaintiff fell. CBRE would have no reason, as the Cleveland Clinic admitted, to constantly remind Davy Tree to, hey, make sure to salt that area, make sure to salt that area, when everybody admits they were already doing that. As for the condition of the parking lot itself, as the saying goes, a picture is worth 1,000 words. And CBRE attached the picture to both its motion for summary judgment and on page 6 of its appellee brief here. That picture on page 6, and I have copies if anyone would like to see it, shows a well-lit, completely dry parking lot other than one obviously icy area. The open and obvious doctrine doesn't matter if the plaintiff herself saw the icy area. She admitted it was wet. She admitted she could see it was wet. She takes an issue with it wasn't obvious that wet pavement was ice. As Ohio law has repeatedly held, that is the distinction without a difference. In Ohio winters, wet pavement is the open and obvious hazard of black ice. This situation, and furthermore, it's the natural accumulation of ice. So CBRE has two fronts, and the trial court agreed with both to prevail, and why this court should affirm the trial court's opinion. One, if it's natural accumulation of ice, plaintiff's claims against CBRE are barred. It was an elevated helipad created by the Cleveland Clinic, not CBRE, so the creation of the hazard does not affect CBRE whatsoever. Furthermore, this court, as well as multiple courts throughout Ohio, have repeatedly held that a man-made structure that allows water or snowfall to come off of the elevated structure onto land and then it pools and forms into ice is still the natural accumulation of ice. It is undisputed that whatever the water source was on January 3rd, 2019, whether it was melted snow, rainwater, or groundwater from the natural springs on the property, that's a natural source of water that flowed downward into the parking lot. It's undisputed that's a natural accumulation of ice that was open and obvious. Mr. Bartko, the security guard at the Cleveland Clinic, approached this same scene 5 minutes after plaintiff fell. He said he could see the obvious ice from 50 feet away. As this case involves an open and obvious slip and fall on ice, which CBRE had no duty to plaintiff to warn her of open and obvious situations, and no contractual duty, as it did identify the issue, did report it, and it's up to the Cleveland Clinic on what plan they want to rectify. The Cleveland Clinic surely knows what a drain is. The Cleveland Clinic decided to instruct Davey Tree to handle it by heavily salting and monitoring every time that temperature went close to freezing. Davey Tree, it is undisputed, performed those services for the next 22 months, and nobody heard a single complaint about ice. If appellant's argument is to be believed here, then CBRE would be liable for a breach of contract based on one March 2017 email till the end of time. This fall could have happened 5 years from now. And no matter how long Davey Tree apparently heavily salts this, the plaintiff appellant would have you believe that if they messed up on one occasion, notably in this case, while CBRE was not on the property, so had no duty to even see this, everybody is aware CBRE's last employee left 3 hours before this fall, there was no ice on the property, then CBRE would be eternally liable for each and every situation that Davey Tree might have messed up, or whether they messed up at all in the future. That is CBRE's position. I'll take any questions that you have.
Apparently there aren't. Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court, counsel. My name is Taylor Ikabachi. I'm here on behalf of my client, Davey Tree. Most of my arguments today on behalf of Davey Tree do align with CBRE's arguments as well, and so I will try to focus my arguments mostly on Davey Tree here. But again, this is a very simple slip and fall case that does not warrant reversal by the appellate court here. And some of the things I want to focus on today are some of the plaintiff's own deposition testimony that she's testified to, which really does not help her here. She testified that on the day of the fall, she was very familiar with this parking lot. She used this parking lot every day when she worked. She worked at that Twinsburg facility since 2011, and so was parked in the same spot. Again, she knew that there was water flow in the lot and testified that it occurred 2 to 3 times per week without any rhyme or reason, regardless of the season. Again, she also knew that the area was heavily salted, and that is to the credit of Davey Tree, and even joked about the amount of salt with her coworkers. She was never worried about falling because it was heavily salted, and admits that she was not exactly looking at that area, again, because it was heavily salted. There was testimony that the ice was present from 50 feet away, and that was the only icy area in the entire parking lot that day. However, Davey Tree did not have a duty to service the area on the day of the fall under its contract. And again, I know we have read the relevant portion of the contract, so I'll just reread a short section of it, stating, snow removal is required at a zero tolerance with a maximum of 30 to 60-minute response time for all locations. Heavy snowfall and icy conditions will require additional and continuous service by vendor. Now, this response time language means that it is in response to something. There's a triggering event. Here, it would be a weather-related event because this is a contract for snow and ice removal.
Was there some discussion in this particular case of this property that there were need to be there occasionally because of this water leaking, so the snow removal thing it might work for regular properties, but they knew we had this problem here that Davy Tree didn't do, they had to go for that, put ice on there when it was a cold day when there's water moving up property.
Yeah, and that's a great question, Your Honor. My response to that is that it still doesn't mean 24/7 around-the-clock care. And Davy Tree, in my opinion, has went over and above its duties under its contract by responding and heavily salting to that area because it knew that that area had the water flow. So, yes, it knew about it, but under the contract, it really was just going above and beyond. And even if it did, they still have not established that the 30 to 60-minute response window was expired at the time at which she thought.
But I think maybe Judge Stevenson's question, I don't want to put words in his mouth, seems to go to whether there really was that response time in regard to water that was flowing that they were put on notice of, and they routinely salted it regardless of having anybody notify them.
Well, they did not have anybody notify them.
I understand. So the point is, if they were salting it without people notifying them, why didn't they salt it that day without being notified?
Well, the issue here is that the water came down without any rhyme or reason, and regardless of the season. So, yes, they had salted it over and above their contractual duties that required it, but that day in particular, they didn't have a duty to go that day because it's not, what's required of them is not 24/7 around the clock.
You know, I'm not sure it's in this case, but whenever you were talking about that, and when you say that the appellant here wasn't really even watching because it was a joke that it was so heavily salted, an argument could be made that maybe it's assumption of a duty, you know, that people became so relied on that in the respect that it was constantly salted, and it was a big joke because it was so heavily salted. And then one day they don't salt it and somebody calls.
Your Honor, to my knowledge, the appellant has not made that argument on appeal. So to my knowledge, that argument is waived on appeal. But even if they had made that argument, I would still refer to the open and obvious doctrine and state that she was familiar with it. It was not hidden. And
In your position, is the open and obvious doctrine applies to the entities that were servicing the property and not just the property owners?
yes, Your Honor. My position is that, and Johnson has argued that it doesn't apply. However, it does apply, and I'll refer you to page 19 of my brief. And the open and obvious defense is available to independent contractors so long as they did not create the dangerous condition. And I don't believe
Does it
that.
also apply to an argument of a contractual duty? In this case, I understand the plaintiff to be arguing that the contractual duty owed to from your client to the plaintiff, open and obvious applying to that contractual duty as well?
My opinion is that it does, Your Honor. I don't have a cite for that off on the top of my head, but my position and my argument is that yes, it absolutely does.
And just, I see you running out of time, can you briefly touch on the third-party beneficiary argument in this case? Do you agree that your position, your client is, the plaintiff will not a third-party beneficiary to this contract?
Yes, Your Honor. Yes, that's my position.
Why is that?
Well, I think it's an ancillary issue. I do think that Davy has stronger arguments in that didn't have a duty to go to FA, did not have a 24/7 round clock care, but it specifically states in the contract no third-party beneficiaries. It is a specific contract position. And just briefly, Your Honors, Davy Tree was not told that there was ice that day, and despite visiting the site 2 to 3 times per day, and on occasion using 40 to 50 pounds of salt, there was not any amount of salt that could have prevented this.
Is there evidence they were there a couple times on January 3rd, the day of this fall?
No, Your Honor. But this is not a situation where it's like the equivalent of a nurse having to go around and chart each time that she looks at her patients. It's
I
not-
was based upon your comment that they're there 2 times every day, if there's evidence they're there 2 times that day or not.
No, Your Honor.
And counsel, you're out of time, so why don't you sum up, please?
The Davy Tree would just ask that this decision be upheld on appeal. Thank you.
Thank you so much. And you only have 29 seconds left, so you have to be a fast talker.
I will probably be a fast talker. Thank you. Real quick about the open and obvious, they talked about Mr. Barco, who came out and said that he saw it from 40 to 50 feet. This is after he was already notified that there was a fall on ice there, so therefore he was looking for this issue to come up as well too here. My client had testified that, yeah, it was always heavily salted, so she wasn't necessarily looking for there to be ice. And even Mr. Luketic from CCS said that it was reasonable for the employees to expect that area to be salted, because that was the responsibility of Davy Tree to do that in those circumstances here.
Thank you.
Thank you, Mayor.
Thank you to all of the parties for your arguments today and presentations to the court. We will take the matter under advisement and issue a written opinion that will be sent to the parties as well as we release it on the Supreme Court website, so you can look for it electronically as well. Thank you again.